So Ms. Huey, good morning. How are you?
Good morning.
Yeah, Irv Condon. Good to see you.
Good to see you.
I'm just trying to gauge the audience. Are you here for estate planning, or did you lose somebody and need to go through the probate?
My father passed away
Oh,
a couple weeks
sorry for your
ago.
loss. Sorry for that.
Thank you.
Here in Charleston County, or?
So he had my childhood home was in Charleston County, but I'm actually live in Aiken County.
Okay. Yeah. That's the beauty of Zoom. We can be anywhere. You don't have to drive all the way here. Yeah. Yeah. I guess you'd be more interested in the probate process then, yeah.
Right.
Did he own real estate, or do you know?
I believe the home was paid off. I believe he owned it outright. But he took out a reverse mortgage a few years ago.
Mm-hmm.
So I'm just trying to figure out where I go from here.
Okay.
I don't know if the process is different with
Sounds like
him having this.
it's probably our normal administration, since he had property, the real estate's in his name. It wasn't joint with right or survivorship with anybody, was it?
No.
Okay. Probably normal administration, we get that. Yeah, good morning, everyone. Irv Condon here with Probate Court. Good to see everybody. Yeah. And just trying to gear how I need to address most of you, whether it's estate planning or whether it's the probate process or something else. Okay. Ms. Williams, are you probating in the state or?
Probate.
Probate, okay.
Mhm.
And is it Miss Diedrich? I guess you lost someone also, yeah.
Well, for me, it's just estate planning for my own benefit to figure out for my children. So we're a little behind in that game, and I want to make sure that we have all our ducks in a row.
Okay.
I still got the papers to probate it.
Good morning.
Good morning. How are you doing there?
I'm fine. How are you? Clara
Good.
McFadden and Brother Frederick.
Oh, good. Irv Condon here. Did y'all
Yes,
lose
sir.
somebody or here for estate planning or probate?
Yes, sir. My brother Frederick lost his wife tragically 2 years ago.
Oh, sorry to hear that.
Yes, sir. Thank you. Thank you. So we're just trying to get some instructions as to what to do with this paperwork.
Okay. Did she have real estate in her name, or do you recall?
Well, she has some property, but my daughter has she has her father left her some property here and there, but like I said, she was just a private person, you know, after the parents died. So my daughter got property, and then she had property. It was both to my daughter and to my wife.
Okay.
Mm-hmm. And then we just want to go by and see how we can just get it all in my daughter's name and see what else we can do.
Okay. Is any of the real property in your wife's name? Is it all in your daughter's name now?
It's in both names.
Both names. Okay.
But like I said, but after a while, we didn't know whether she was paying the taxes on it or this and that there. So we got to go find out everything what was going on.
Yeah.
Since they had, COVID, the pandemic, we couldn't do with so much.
Right. And that's why we came up with this virtual workshop, the Zoom. Yeah. To do it in person. Okay. So we got a little bit of both, a little bit of estate planning, and then a little bit of probate. Okay.
Right.
And I have on here also from our office, Miss Jamie Robinson. And
Morning.
Good morning.
Good morning. I have to come downtown and meet you. You've been so very helpful to me.
Jamie is the
Oh,
best.
thank you.
Yeah.
We're gonna have to make sure that Santa makes his rounds to your house this year.
She's got reindeer in her backyard. She's got.
Oh, okay.
Yep, I live in the country.
Oh, well,
Several deer.
I know that feeling. I live out in Walterboro. Frederick lives here in North Charleston, so I came up down this morning to help him, with this session. But yeah, living in the country is a luxury in itself if you like that kind of lifestyle.
Her country, though, is just across the Cooper River Bridge. She's not way up.
Oh,
Happens to have some deer back there.
Okay. Well, I'm about 13 miles from the city of Walterboro. I live near Kennedy's and the Edisto River. So you're liable to see, wild turkeys,
Wow.
wild hogs, foxes.
Nice.
Yeah, lots of deer. So I know what the country life is like.
Okay, all is good.
Yeah. Yes.
I've got a question, please.
Sure.
Some of the estate that I'm trying to get settled out, some of the is in Florida also. So with the laws, what we're discussing this morning, would it be applicable to Florida also?
In a ways, yes. If the person has an estate here and you probate it here, and you've got some real estate that they own in another state, you do a thing called ancillary probate, and we send documents down to that other county court, and then they process it that way.
Okay.
Now, I assume it's a South Carolina resident that has property in Florida, or is
Well,
it?
actually, my sister was a resident of Florida, but she became ill and she moved here with me in South Carolina, and she stayed here 3 years with me before she passed. I was her POA also, but I never, I went through so many things when she was ill that I've never tried to do anything with the state. And it's been almost 3 years now. So.
Okay. Did she own any property in South Carolina, or did she become a South Carolina resident?
She became a resident here, but she didn't own any property here.
Okay. So she ended up getting her bank accounts here and everything.
Right.
Okay.
Right.
Yeah, the power of attorney dies at death, and so that would be in her individual name.
Right.
If she's a South Carolina resident, you could probate it here and then do the ancillary probate for the other state, for
Okay.
Florida. Yeah.
Okay.
But if she's a Florida resident or all her property's in Florida, then we start there. But either way, yeah.
Okay.
Sounds like South Carolina and then go to the other.
Okay, thank you.
Sure. Any other questions before we get started? I was just trying to figure out, it looks like some are interested in estate planning, some are for the probate process. I've got all day. Y'all tell me how long y'all want me to go. So people in the country got all day too. They want me to go. If you want me to go an hour, I can do an hour. If you want me to go longer, I can do longer.
I would think an hour is fine, but that's just me.
Okay.
You never know how many questions people have.
Right. Okay. Well, I'll tell you what, I'll run through the slide presentation here, and I'll stay on afterwards if anybody has any questions. And again, Jamie Robinson is on from our office, and Jamie's been with me for well, in private practice, and then almost 30 years, 30 plus years we've been together. So Jamie, jump in if I miss somebody or if you can help answer any questions.
Yes, sir.
Okay, anyway, we generally do these in person. We've been doing it by Zoom based on the pandemic. Generally, it's just an overview of probate court and jurisdiction. A lot of people looking for their probation officer. We have little to do with that, except in our problem-solving courts. And then we just talk about estate planning for the family. We'll talk about civil commitments, one area of the probate court for the mentally ill and for those on alcohol and drugs, those that will not get help. There's a way going through probate court that we can get our family members help. And that'll give you some points to ponder, some trivia. All right, first off, what are the 2 rules on judges' jokes? Go to a courtroom, what's rule 1? Only the judge tells the jokes. That's rule 1, okay? Figure out what rule 2 is.
Everybody laughs, right?
Everybody laughs, you're right. No matter how bad the
Everybody
joke
laughs.
is, everybody laughs. So we got everybody going. 2 rules there. That'll help you if you get a speeding ticket and you end up in court. Just remember that. Okay. Anyway, these are topics generally cover estate planning. We talk about the probate court, our divisions there, our problem-solving courts, and then we'll talk at the end about estate administration and basically the 3 ways to probate an estate in South Carolina: the summary, the normal, and the contested cases. Here's a little eye test for you, and here's an organizational chart. And this will help you if you're probating an estate. If you look over in the left-hand column, we've got our estate division there. You see Allison Atwood's our clerk of court. And then we've got 5 estate clerks from Tina, Sharon, Nicole, Talisha, and Teresa. And they all have cases you'll see by the ending number of the case file. So in 2022, it'll be 2022 ES, meaning estate, 10 will be the county, and then there'll be a number. And we start with the number 1. So we're probably on like 842 today. So if it was 842, the number ending in 2 would be Nicole. So Nicole would help the family from beginning to end. And so just keep that in mind. It helps us even out the workflow among the 5 estate clerks. They're there to help you. If they're not available, the others can step in and help you. And you'll see Jamie down there. She's our estate's project officer.
I'll call her back. Tell her I call her back.
Okay. Need some of you. Okay. Estate division, we do about 2,200 estates a year. In the middle there, we got commitments and guardianships. Commitments, we'll talk a minute here. We do about 1,800 of those a year. That's alcohol and drug and mental illness. Guardianship and conservatorship. We got Jennifer, Tina, and Elizabeth. They do our GCs, guardianship and conservatorship. We want to avoid the guardianship and we want to avoid the conservatorship. We avoid the guardianship by the use of a healthcare power of attorney, which we'll talk about more here shortly. And then we avoid the conservatorship by the use of a durable power of attorney for business affairs. And then we also can use a trust to avoid the conservatorship. So guardianship is of the person, healthcare, medical decisions, conservatorships of the money. And probate court has jurisdiction over adult guardianships and adult and minor conservatorships. Family court has jurisdiction over minor guardianships. We have about 1,000 of those cases open. And we've got 4 problem-solving courts: the adult drug court, juvenile, mental health, and veterans. And we'll talk about those. We've got law clerks and financial people to help also. And here's your eye test. Everybody's got a contact information. And keep in mind, if you ever need to get in touch with one of the estate clerks, say it was Nicole, you'll see her direct dial number there at work. You'll see her cell number. We're all set up to work from home remotely during this pandemic. And then they also have their email address. So they're there available to you, even if they have to be working remotely. We're there to help you, our citizens. Okay. We're located down at the Four Corners of Law, and the mayor's office is down on the bottom left. Jamie's in that the historic courthouse on the right. I'm in the brick building on the bottom right. Across the street is the federal courthouse and post office. And then the highest law is over there on the left, which is the church. And that's known as the Four Corners of Law. And a legal historian, guess who gave it that name? In person, I'd have a candy bar to the winner, but we're not in person today. Robert Ripley. Ripley's, believe it or not, gave it that name. It wasn't Riley or Rutledge, it was Robert Ripley. This is how it looked back then. It was actually the state capitol before it moved to Columbia. This is how it is refurbished today. It was done by an Irish architect by the name of James Hoban. At that time, it was illegal to educate an Irishman. Somebody got him educated. He went over to Philadelphia, then down to Charleston. George Washington visited our city, liked the work Hoban had done, and he bid on some other buildings. He ended up being the architect for the White House. So you see the White House on TV. Remember, it's a Charleston architect. He modeled it after the Leinster House, which is that portrait behind him. Our model of our courthouse is on the desk there, Washington's bust, and then the White House in the portrait there. We're over in Ireland here. That's my son in the plaid pants. Our luggage didn't make it. And so we had to buy some plaid. He didn't know what quite to do with that Irish girl there, but we had a good little marker and dedication there. All right, probate court, we're in two different locations. Remember, we're the Holy City. They did not want a 7 or 8 story building here. Our tallest is basically 3 stories. Historic courthouse, Jamie's in the building on the left. I'm in the building on the right. And they're both located right at the Four Corners of Law. Okay, here's some basketball for you. Might watch the NBA. What's the highest basketball court in the land? I guess. Highest basketball. I got everybody muted. Okay. It's the U.S. Supreme Court. Can you believe that? Highest court in the land. Above the U.S. Supreme Court chamber, guess what? There's a basketball gym. You can't shoot hoops while they're in session, but there's a basketball. I made 2 shots there and I retired. Not even Michael Jordan has scored there, but I made 2 shots. If you get the nickel tour, you can get up there and take a shot. This was my mentor. Jamie and I both worked for Morris Rosen, Southern gentleman, practiced. He loved helping people, practiced to nearly 90 years old. He passed about 10 years ago, but loved helping people. And we try to take what he taught us and help others. All right, let's talk about estate planning. We all need to plan our estate, and the goal there is to get our property to the people that we want it to with the least expense, and always have alternate takers. It also is to help our family decide, to tell our family how we want to be treated at the end of our life, so that we know that we are treated that way. And then where we want, as a funeral home director would say, their job is to get the body to where it belongs and to get the people to the state where they belong, which is going through that grief process and then coming out the other end. Okay. All right, here's a sample of a will. This is what we don't want your will to look like. We eliminated the witness signatures and the signatures of the individual, the testator. If you look on the right, you can see it's like he had either a grocery list or a list for a recipe. And then on the left, he did his will, which is one sentence, basically, leave everything to my beloved wife. We want a little bit more than that, but that's just an example of what we see sometimes at the court. I don't know if he was going to the grocery store and then did his will and then passed, or what actually happened, but we never know when God's going to call us. We need to make sure we get our estate planning done. In that regard, we want to look at 11 documents, and this is what we want you to consider. And I know, Jamie, you sent them out the checklist and all copies of these documents. And so the first you would start with is the checklist. Some attorneys will call it a questionnaire. You want to list all of your assets and how they're owned. And keep in mind, always important to go back and look at the source document. Many times we may think an account is held a certain way, and then lo and behold, it's joint with right of survivorship or it's payable on death. Same with real estate. It can be tenants in common, which means husband and wife each own 50%, or it could be joint with right of survivorship. So you want to take a look at that, make sure that how you own it. So you want to get all your source documents, and you can save yourself some time and money because the less time you spend with the attorney, they generally charge on an hourly basis, the less it'll cost you. And then you checklist or questionnaires will then ask you a series of questions of who you want to leave it to, who you want your fiduciaries, your personal representative to be, the agent under your power of attorney. So you go through all those things. The goal here is to put in action, in writing, either through a will or will substitutes, what you desire. There is no right or wrong answer here. The only right answer is what you desire and making sure that that's carried out. And that's the duty of the attorney, to make sure that your wishes are what are reflected in the legal documents. And there's a number of ways to do it. Again, I mentioned will substitutes, such as a joint account with right of survivorship, or having it all go through your will. Now, when we look at number 2, you got a sample of a will, last will and testament with a trust. Remember, a trust is just a vehicle to hold property until the person's of the proper age to handle it. Generally, we would recommend for a child, maybe give them 1/3 at 25, 1/3 at 30, 1/3 at 35. So they learn along the way. And if they need to invade it for healthcare or medical issues, they can, or if they have educational needs, they can, but hopefully they don't go through the money all at once. So if you don't have a will and you die intestate without a will, then a conservatorship will be set up for those minors, and they receive the property at age 18. And most people think that age 18 is not the time to receive something, that they need time to maybe 25, 30, and 35 are the ages, but you've got to decide with your kids and grandkids what's best for them. We had one child that couldn't receive the property until age 65. It was a little more restrictive, but I think the parent wanted to make sure that the child had Social Security, a safety net there for them. And so in a will, you can decide who receives your property and when. You can decide who your fiduciaries are, called a personal representative. Used to be called executor or executrix. You want to also lay out, if somebody dies, who the next taker is, alternate takers, alternate personal representatives. So the attorney will go through that with you. Will has to be in writing. It has to be witnessed by 2 individuals. And if it's notarized, then it becomes self-proving, which means you don't have to bring in the witnesses if it were ever contested. To make a will, you have to have testamentary capacity. That means you have to know, it's a 3-part test, know the object of your affections, who you want to leave it to, and generally know what property you own. And again, there are formal requirements, and that's why it's important to go to an attorney to have your will done. And we'll talk a little bit later about selecting an attorney. Another important document I mentioned earlier is this financial or business power of attorney. It's called a durable power of attorney. That allows someone to act for you if you become incapacitated. Under strict agency law, if I named my wife as my agent and I became incapacitated, say I was getting surgery and I was under medication, she could not act for me under strict agency law. But if it's a durable power of attorney, then that power of attorney is not affected by the mental or physical incompetence of the principal. So then she could act for me. That's generally what we want. One little caution here, a couple cautions. One is that a power of attorney is not regulated. So you've got to get somebody that you trust very much to be your agent under the power of attorney, because they can handle your assets as if they're theirs. So you got to have somebody that's trustworthy. The other thing is, if your estate plan is, I've got 3 kids and I want to leave it equal to all 3, if you put a child on the joint account with right of survivorship to help pay the bills for you, when you pass, that joint account will go to the surviving joint tenant, which is the child. If that's what you intended, that's fine. But if that's you wanted it equally to the 3 of them under the will, then you need to put the child on there as the agent under the power of attorney. Again, a power of attorney ends at death, only good during the lifetime. A financial or business power of attorney, to be effective, has to be recorded at the Register of Deeds office. And another document on the healthcare side is the healthcare power of attorney. I'll talk about that. And then the next document, a declaration of desire for natural death, also known as a living will. Those are two what we call statutory or forms. They're right out of our code of laws. They're the same for all in South Carolina. This allows our medical personnel, our hospital workers, to see the same document each time. So a healthcare power of attorney is a form document like the Declaration of Desire for Natural Death. And you have a number of selections you can make. The documents have great flexibility. You can have maximum treatment. You can withdraw treatment. You can put it in your own words. They'll talk about organ donation. The living will talk about revoking it or enforcing it. But if you look at those documents, it's very important to have this on the healthcare side. The living will, which deals with your end of life issues, is many times confused with the revocable living trust. Living trust deals with property. It's a trust that you set up during your life and you put your assets in there, and it's a separate vehicle. Many people do that. It avoids probate. Most South Carolinians are fine though going through probate, as the filing fee is $95 on the first $100,000 of probate assets. Many times you're going to incur more administrative costs doing the living trust than doing a last will and testament with a trust inside it. One is the living trust. Another name is inter vivos trust. Trust inside a will is called a testamentary trust. It comes into play once you pass. Another document that was emailed to you is the 5 wishes. That's number 7 there. That is a national document. If you take a look at that, it's got the 5 wishes there, and you can put in writing basically how you want to be treated at the end of life. The 5 wishes came about. It's a nonprofit out of Florida. Most Americans do not talk about death and dying. And we know what the 2 things that are certain are what? Taxes and death. We just paid our taxes and now we know we're going to pass. So the 5 wishes is a movement to try to get Americans to talk about death and dying, because it is certain it's going to happen. And you can put in writing in layman's terms how you want to be treated and how you want others to be viewed going forward. There's also, if you want to do cremation, you can put that in there also. So the 5 wishes, a national document, and that's acceptable here. It's allowed in South Carolina. The main thing is to be consistent on all these documents. Your healthcare, your living will, your 5 wishes. Don't put maximum treatment on one and withdraw the treatment on the other. Be consistent. Number 8 there is a DNR, do not resuscitate order. I lost a brother to cancer several years ago. He had a DNR, he knew the cancer. He was in the hospital battling it and knew that it was just a matter of a week or 2. He executed a DNR in case he had a heart attack that day, that he could go ahead and pass, because he knew the cancer was going to take him in the next week or so. So that's another thing that it actually helps your family members, your loved ones, know what your wishes are, and takes that burden off of them of having to make that decision. So here's a chance while you're have capacity to make those decisions. Along those same lines is this physician's order for life-sustaining treatment called a PULSE. We are piloting this over at Roper St. Francis Cancer Unit there in West Ashley. And again, it's a combination living will, 5 wishes, DNR, healthcare power of attorney, but allows an individual to make those kind of decisions. Organ donation, it's something of personal choice if you want that, and I'll show you a slide here. Cremation, more and more South Carolinians are choosing cremation. Michael Jordan's dad, James Jordan, was tragically killed in North Carolina. His body was dumped in South Carolina. The rural county didn't have space to keep him. They took a dental mold and cremated James Jordan. There was no safe cremation law. State legislature stepped in, many state legislatures pass a law that before you cremate a body, you have to have due diligence to try to locate the family members. And then it also gave a way for, if you want cremation, to go ahead, get with your funeral home director and do a pre-need authorization, get with your attorney and put it in your will. Or if you don't do those, then all the family has to agree after you pass. And if they don't agree, then you're down at probate court. But more and more people are choosing cremation. It's probably 60 or 70% of the business for funeral homes. I talked to them, they said 30 years ago, they didn't know how to spell the word cremation. Now it's most of their business. I'll pass the jokes today and we'll go to the Coastal Community Foundation. Or Jamie, if I hit,
If you hit the cursor, you put your cursor on the,
yeah. All right, y'all ready for a good
Yeah,
joke? Y'all can
yes,
tell
sir.
me up or down on this one. This man got run over by a steamroller. Do we keep it or do we put it in the trash can? Y'all tell me. If it's good, we'll keep it. If it's not, we will. You're our test audience today. You're
It's a keeper.
keeper. Okay. Try to get some levity. Try to get you to smile. It's talk about death and dying. It's tough. If you want to help others and want to get around the administrative costs, any community foundation can help you. We're blessed with the Coastal Community Foundation. We had somebody that had $50,000 in their will to help somebody in Charleston County go to college. If they set up their own foundation, got to qualify for the tax commission, the IRS, use the CPA and tax attorneys, going to use up most of that $50,000. They could simply go to the community foundation and set that up. Center for Heirs Property. If you have heirs property, they will assist you. They will either help you probate the estates or do a quiet title action over through common pleas and the master in equity. They were located west of the Ashley. They just moved up to North Charleston at the Opportunity Zone up there on Rivers Avenue. But go to their website. I know we got some on from Walterboro, Colleton County. They cover the whole South Carolina coast here, and they're moving more inland, but they can help you. And with the help of Reverend Clemente Pinckney, they passed the right of first refusal for an heir. So before an heir sells to a developer, the other heirs have a right to buy the land. But they can help you get clear title. They also do wills clinics. So check out their website. Very helpful organization. We talked about selecting an attorney. This is one service free of charge. It's called Martindale Hubble. You can look at attorneys in your area. It's by location. It's also by specialty. You can look at their background. You can look at their peer rating, A being the highest. And so here, Martindale Hubble, you go to their service. You can go to Charleston. You can go to where you live and find an attorney. And then you can look at their credentials and that peer rating. And this is much better than picking somebody off of the TV. So I recommend Martindale Hubble. If you cannot afford an attorney, there's Charleston Pro Bono Services. Somebody asked if this recording will be made available. Yes. And Jamie, we are recording this and it will be available later. We also have one out there that I did right at the beginning of the pandemic. So if you can't sleep at night and want to listen to me, you can get on 24/7 and we'll get Jamie to send out the sites for that. Charleston Legal Access is another one that they charge on a sliding scale, but they can help you also with estate planning and probate. The Palmetto Project, we just added a slide. We saw this presentation last week. If you've got questions on Medicare and Medicaid, this Palmetto Project, go to their website. They have some very helpful information. And they, I think it's Shelley, there, different people there can help you. But they are very helpful if you've got issues or you got questions on Medicare and Medicaid. Organ donation, I mentioned that earlier. This Donate for Life, we can now do it in our different advanced directives. You can also download their forms. You can also do it on your with your driver's license. Then we always recommend everybody to take a ski vacation. Any skiers here today? Well, everybody take a ski vacation. All right, SKI, if you learn anything from today, remember this one. And that is the spend the kids' inheritance. Go ahead and spend the kids' inheritance. It's ski. You see so many people pass and then we're going to go do this, go do that, or help somebody. It's not necessarily taking a trip. It may be helping a grandchild or somebody that needs help with their wedding, or they're buying their first home, or getting a car, or going to college, or going to the prom and just need help. So we never know when God's going to call us. So always consider that. And I always tell the younger generation that they need to be very nice to their parents and grandparents, because South Carolina about 3 years ago added the pet trust to our code. So you can now leave all your property to your dog or your cat or whatever pet you have. And we had 2 dogs here in Charleston County. They got $900,000. Couldn't be kept outside on a chain. And then after they passed, they went to the SPCA. We had another dog out on Kiowa. They got a home. So think about that. There are pet trusts. You can do that. And I always tell, so if your kids aren't nice to you, just remember you got the pet trust, okay? I always jokingly tell them that. Let's talk about wills, probate, and estate administration. We'll talk in more detail after I run through these slides, but this is generally an overview of what you need to know for estate administration. If you have an estate that's under $25,000 and no real estate, you can open and close it 30 days after a person has passed. The second and most common way is what we call normal administration. And it takes 9 or 10 months to probate in the state. And that's because our state legislature chose a creditor's period of 8 months. So once you publish in the newspaper, a creditor says it has 8 months to come forward. Some states are 4 months, some states are a year. We're kind of in the middle at 9 or 10 months. In normal administration, it's an administrative process that we'll see. And you basically give notice to everyone, what we call interested persons. People that are named in the will are called devisees. Those that would take, if they're not a will, would be our heirs. They're given notice, written notice. And then we also give notice to a third group, which are the creditors for that publication. So it's an informal process. You file the documents with the court. Most of them go through, and then at the end, you send out closing documents. If no one objects, then it closes administratively. And you'll send them a notice of right to demand a hearing. You'll send them your accounting, and we'll look at that in more detail here in a minute. Contested cases, few of our cases. In fact, the will contest has kind of gone away. When I first started here nearly 30 years ago, we'd have 4 or 5 will contests filed. 1 or 2 would go to a jury trial. The generation now, and this is a national movement, they're not waiting until mom or dad pass. They try to get the money while they're alive. So the battles are in the powers of attorney, the joint account, and the trust matters. So you can have a contested cases, few of our cases, but it requires notice and a hearing each step of the way. Keep in mind, you can start with the summary proceeding and then realize, oh, I've got real estate. I go to normal administration, and then some type of contest breakout, so you can end up in a contested proceeding. But South Carolina has a version of the Uniform Probate Code. And again, it's allows it to be done informally. We also will highlight, we've got e-filing now, which is in person was the only way you did it back then. We now have this easy electronic filing, and you can file everything electronically from around the world. And there's a $7 time fee that goes to the computer company out of Atlanta. You pay that $7 convenience fee, and then you can file as many documents as you want. And more people are choosing the e-filing. For those that don't have the scanner or the computer or the ability to do this, Jamie is headlining this, but we're setting it up at our local libraries and our senior centers. And so you'll be able to go to the senior center and local library. We were up in McClellanville last week, which is about a 40-minute drive up there and 40 miles or so. So they won't have to drive all the way downtown. They can go to the little library there and file electronically. And we're excited about that. Again, it's only a one-time $7 fee, and you can file as many documents as you want. By the time you drive down here to the courthouse, pay to park and walk up, I think that convenience fee is well worth it. Now let's talk about trusts and estates. Remember, we lost to Charleston 9. Tragically, I went to school with Billy and Randy Hutchinson, and played ball with them in that Sofa Superstore. We found that most of our first responders considered it bad luck to get a will. And they're the ones that need a will. They're the ones in harm's way. We lost a police officer, fireman yesterday. Tragically, they're in Columbia. So we're trying to make sure that our first responders all have the will and estate planning done. And hope that you'll consider that also. The Emmanuel 9, they showed us that love conquers hate and no violence after that. Lovely families that I was able to do an estate workshop for them. About 2 weeks after this tragedy, we met at the local library and we walked them through the probate process. Reverend Clemente Pinckney is there in the middle, and he was instrumental in getting the right of first refusal for our heirs. Again, they showed that love conquers hate. They had a trust matter. Clay Matthews here, senior, actually was a boxing coach at the Citadel. A lot of his sons and cousins played in the NFL. They had a trust matter, and we helped them reform that trust. This individual actually won the Masters back in the 30s, and he had a will interpretation case that I heard in the early 90s. Shoeless Joe Jackson allegedly threw a World Series. He only signed very few documents. One was his will. The residuary beneficiary, a charity, sued the probate judge to get the original will, because to a baseball collector, his signature on that document is worth like $75,000. But the Supreme Court held that all documents, once filed with the court, stay with the court. So if you're famous, you file your will with us, it'll stay at the court. The Countess that started Spoleto used an attorney from West Ashley. So just keep in mind to go to an attorney. We have very good, capable local attorneys. And you can name your living trust any name you want. James Brown named his I Feel Good Trust. And there's still some litigation over in Aiken. I think somebody was joining us from Aiken today, but that's where that trust matter was probated and some litigation there. Now, marriage licenses, I'll run through this quickly. We do about 5,000 of these a year. Charleston's a wedding destination. It's a something that we handle here at the court. And again, we've got where you can do it electronically. We've got a love program. It's live, online, virtual e-marriage application. Law clerk came up with that name. So you can apply online, don't have to come downtown. So if you've got grandkids or somebody, children getting married, they can apply online, and we service anybody in the state of South Carolina. Who's coming through? Dr. Gupta with CNN, married Charleston girl. Reese and Ryan got away. Blake and Ryan got married over there on Mount Pleasant. I think she lives out on one of the Barrier Islands. And Foodies actually came through. So everybody's coming to Charleston to get married. And we're happy to accommodate them as they stay in our hotels and eat food in our restaurants. Another very important area for the probate court that we all need to be aware of or civil commitments. This is where someone suffering from mental illness or alcohol and drugs will not get help. It's a family member, and we're trying to get them the help they need. And that's the civil commitment process. And that's where a family member can come to the Charleston Center or to the Dorchester Community Charleston Community Mental Health Center, complete paperwork to get their loved one evaluated. And then we hold those civil commitments at the Institute of Psychiatry at MUSC, Palmetto up in North Charleston, or the VA. Again, this affects all of our families, and we just want people to get their help. It's they're closed hearings. It's not a criminal matter, it's a civil matter, just trying to get the people they help, our family members, to get the help they need. Cases that have come through. Alice Boland here actually went through civil commitment, and actually we almost had a tragedy, almost a Sandy Hook there. She had a gun outside of Ashley Hall there when the girls were in line to get picked up after school. Here's our mental health centers, just so you know: Institute of Psychiatry, Palmetto, and Charleston, Dorchester. We have a separate alcohol and drug unit, and that's the Charleston Center. It's part of the statewide system, Department of Alcohol and Other Drug and Abuse Services. For our veterans, any veterans here today, we're blessed to have the Ralph Johnson Medical Center, named after a Charleston private. Ralph Johnson jumped on a grenade in Vietnam, saving the lives of others, gave the ultimate sacrifice. And we go over, just to point out that we do have mobile crisis. If a person's a danger to self or others, they call us, and then we do paperwork for them. And then we make sure that they go through this due process. They'll have an attorney appointed for them, guardian ad litem, 2 designated examiners. We'll have a hearing, and then we'll order whatever the least restrictive alternative, whether it's inpatient, outpatient, or both, or no treatment. Little talk on our problem-solving courts, trying to give people a second chance. It started the adult drug court here, started the mental health and the veterans court to give people the second chance. Instead of being in prison or jail, they get a second chance to come about. First one started, and Judge Goldstein actually came up and helped us start ours here in Charleston. He's a Brooklyn cop, turned lawyer, turned judge, and a terrible crack cocaine problem down there. We're just trying to get the people that have substance abuse disorder get the treatment they need. I went out to Seattle and brought back the mental health court that allows, we want to keep people on their medications and make sure that they're not harming someone else. And Veterans Court, Judge Russell up in Buffalo, he's not a veteran, started it, but we do have a veteran running our Veterans Court. They may suffer from PTSD. We get them a veteran mentor, just trying to help our veterans get out of the criminal justice system and become productive citizens. Not all of our guys are the smartest that go through drug court. Brian here, guess what? He broke into a house while he was high. Guess what house it was? Chief Mullins' house, if you can believe that. Broke into place of Chief's house. Chief Mullins now in the upstate, Clemson. If you look over the far left, you'll see to my right there, far left, Judge Hendricks joined us that day, and she started a federal drug court across the way, just trying to get people out of prison and give them a second. Brian was paying back restitution to the chief for the things that he had stolen. You see he's got a certificate there, and he got his record clear. Other things we're doing, we've got an adult guardianship program and assistance where we have students go check on our wards. Our county and Phoenix were one of the 2 in the country selected. And then we train over at the law school, training law students to go check on our seniors to make sure that they're okay. And then we do the same thing on our conservatorship. Our money side is we've teamed with Detroit, 1 or 2 counties selected by the ABA to check real-time expenditures as they're being made. These are our online services. I highlight the easy filing for you and also the LOVE program. And then you'll see one estate administration workshop is down there on the bottom left, but we'll send you the one from today also. And then we do free workshops like this. We are out in the community. We were West Ashley last week and McClellanville. I think we're back West Ashley this week, and then downtown and James Island on Saturday. So we do go out in the community and do the same workshop, but I think Zoom is here to stay and virtual, and it's good that people can join us from around the state and around the country. Here are my ski trips. Remember to take ski trips. Went to St. Andrews. My son loves basketball and Harlem Globetrotters. Any Red Sox fans? We went and saw actually they're playing the Braves, so I like that one. I'm a Braves fan. And last year we went out west. Look at my wife there in the middle. Can you tell what's behind her on that wall there? Gotta look close. It's actually one of the top 10 attractions in Seattle of all things. It's all gum there. There's a whole alley with nothing but gum on the wall. Pretty gross. It's called Gum Alley. And then we rode horses on the beach. We went to the Olympic trials there out in Eugene. And then we went to the market there with all the pretty flowers. Okay. All right, let's talk about the probate process. Any questions on estate planning? You can unmute and ask me a question. Otherwise, I'll walk through the probate process. We talked about the 3 ways, which were the summary proceeding, under 25,000, no real estate. We talked about the normal administration, which this is an index for. And then we talked about contested cases, but I'll run through this for you. We start with a death certificate. We need some type of proof of death. Again, if the body is not found, we will hold a hearing. There's 2 ways. If a body is not found, you can have an accident and have testimony based on that. We had an airplane crash off the coast here, and testimony from the individuals, Coast Guard report, FAA report, only found an oil slick. So body missing, you can declare someone deceased that way. The other is if they're missing for a period of time, now it's 5 years. We had somebody hop on a plane, go to Atlantic City, never heard from. Somebody came in and the family came in and testified. Yeah, Mother's Day, Father's Day, he'd always send a gift or a card. Birthdays, he'd always do that, and no word from him for those 5 years. We start with a will. Hopefully they have a will. If you die with a will, it's called dying testate. If you die without a will, it's called intestacy. Intestacy means it goes basically according to your family tree. And we start with an application. And you'll see that this, like most forms, it has good flexibility. The application, we check for probate of a will. If we have a will or appointment, we list decedent's information. I'll highlight over here at 4A and 4B. 4A are the people named in a will are called devisees. Those that would take, if there was not a will, are called heirs. So remember that we're going to give them notice, true and information to heirs and devisees. So if you're in a will, you're a devisee. Without a will, it's an heir. And so logically, we've got a son and daughter that did not take. They have to be given notice of the probate process, and they'll have time to object. But if not, they don't object, then it just goes through administratively. And just some information on the estate, the value, the original's attached, who has priority to be the PR. You also verify on this form here on this application. I know it's not the best copy. Jamie, we'll work on getting a better copy of this. Might be a copy of a copy that's come through on this. But you'd verify the information. The judge is going to end up signing off on the formal probate and appointment. You would qualify and state your acceptance of PR. Remember, it used to be called executor, executrix. It's now called personal representative. Our grandparents used to actually come down and be sworn into the office. It's now done all informally. But anyway, let's see if we got an honest group here today. Everybody raise their right hand. I got to look at your right hand, the palm of your right hand. Okay, let me see everybody. Get your hand high so I can see it on the camera. Okay, yeah, it looks like we got an honest group here today. You can put your hands down. In the olden days, if you're dishonest, they'd take a red hot poker and send you maybe a mark in the palm of your right hand. So they
I've
put-
got a question, please.
Sure.
What if I can't locate one of the persons that I need to notify about the probate? I don't have an address, but I could send a private message through Facebook. Would that be sufficient? Or,
I would do that, but I'd also try to get an address with that private message.
I think he might be homeless, so I'm not sure.
Okay. Do you have others that are standing in the same position as that individual?
No.
I mean, are there others, I guess, that other family members you're going to be giving notice to?
I do have one other family member, but she lives in another state. It's
I
a
guess what I'm
long,
saying is,
tragic story, but the son and it's my sister's adopted son, and he's had a few issues and what have you. So there, I might not be able to locate him. Now his daughter is in college in Maryland. I don't have a problem locating her. But
I
with
would
him,
I would give her notice and then see if she can, and then if she can indicate where.
oh,
he-
they have a restraining order against him. She doesn't.
Oh,
She
okay.
doesn't. So there's not a problem with her, but it is a lot of issues with him. So
There's a way you can do it through a publication in the newspaper. The law also allows, if you say you have 5 people that are basically the same level of taker, and you can give notice to 4, something that would suffice also. If they, I would just do your due diligence and do the best you can. So well, he might be missing, but I guess his daughter you can locate.
oh, definitely.
Yeah. Are
If-
they takers, or are they just are they part of the will, or is it an intestate
They are
estate?
part of the will. It's supposed to be divided amongst the 3 of us. And he's like a terror. That's why I've been putting this off and putting it off, but I decided that I finally gotta go ahead and get it done.
Yeah. I would also advise you maybe to talk to a lawyer, if you got a lawyer helping you, but I would give notice to that daughter as to
Oh,
what's.
definitely.
Yeah.
Yeah.
It sounds like she's going to take the share that he would have, that he would take. Yeah.
Yeah. Which would be fantastic.
Okay.
But I still want to make sure that I try to notify him, and I didn't know whether, me sending a private message because half the time he doesn't even have a phone. So,
Well, I would send a private message and ask if you got an address.
okay.
If you indicate there's property or money, they're probably going to respond to you.
You're right. You're right.
They generally respond when they say that. Okay.
Okay. Thank you.
Yeah, sure. Good luck with that. Yeah.
Thanks.
Anyway, you do the application. You'll get 2 receipts, one an initial fee to open it, and then one for the creditor's selection. And you'll select a newspaper. They're all there. It just depends what's best for you. Yeah, Jamie, we need to update this one. I think we're down to just 3 or 4 3 newspapers now. Okay. But they're all good. The law says a newspaper of general circulation in the county, and it's published once a week for 3 weeks. The court, we handle this publication for you. You choose which newspaper you want, pay the fee, and then we'll send it off to be published. It has to run for 3 weeks. So it'll take 4 or 5 weeks before we get it back, or probably a week to run it for 3 weeks, and then a few days to get it back. Fiduciary bond. This is an insurance policy. If you don't think the PR, personal representative, is going to do what they're supposed to do, you can require a bond. Bond is required on intestate estates. And that's another reason to have a will. You can avoid having to pay for a bond. The bond, really, again, it's an insurance policy that personal representative will do what they're supposed to do. It's calculated just on the personal property. not the real estate, unless the real estate is sold and converted into personal property. The probate code has great flexibility. If you're named as the personal representative, you can renounce your right to serve and nominate someone else. You can also waive bond as indicated there. In renouncing, if you're named in the will as the primary, you can't skip the alternate and renounce to a third party, nominate a third party. The second person named in the will would still have priority, trying to follow the testator's wishes. You would get a certificate of appointment. This shows you that you are in the office of PR, and this is what you can send to the banks, to the insurance companies. Similar to the fiduciary letters do the same. Question here. You're welcome. Someone's got a work call. If anybody needs to leave, just leave when you have to leave, and we'll have this recorded and posted. Here's 30 days after your appointment. You have to send what's called an information to heirs and devisees. And this is where you're trying to give notice to the interested persons. The heirs, again, those people named who would take if there wasn't a will. Devotee are those that take if there's a will. And then you give us notice that you sent the proof of delivery, and that's to, again, the 4 kids there. And this is mom giving them notice. Proof of delivery is filed with the court, basically an affidavit saying you've done by giving them notice. Again, 90 days after your appointment, you're required to file an inventory and appraisement. You're only required to list the probate assets. Probate assets are those controlled by the will or by the intestacy statute. Non-probate, a third-party contract such as joint with right of survivorship, or life insurance where you designate a beneficiary. Again, you see the different schedules there. The one schedule I would highlight is Schedule A, real estate. The one time the federal government is good to you is at death. They give you what's called a step up in basis. Let me try to give you an example of that. If I bought a piece of property 30 years ago for $10,000 and it's now worth $100,000 today, if I sell it today for the 100, I deduct my basis of 10,000, I have a $90,000 income tax gain. If it goes through my estate, my wife sells it a day after I die for the 100,000, she'd get a step up in basis to the 100,000. And so there'd be no income tax gain. That's the beauty of if it goes through your estate, you get that step up in basis. Real estate values you can get from your off the tax records. They may be low. You may need to just ask a real estate agent to give you a letter indicating what the value is. If you have a taxable estate, then you want to hire appraisers, but you're not required to hire appraisers on the estate. Schedule B are stocks and bonds. You can get that from the newspaper, from the stockbroker. Cash is the cash that you own. Life insurance, generally a non-probate asset, but if it's payable to the estate, then it becomes a probate asset. Again, you'll see at the top, life insurance generally payable to an individual. Also optional is Schedule E, which is joint with right of survivorship property. Other assets, you put a ballpark figure down there. And then if you've got encumbrances, or well, we got transfers during the decedent's life, we've got the revocable living trust down there, I'm sorry. And here's some others: powers of appointment, annuities, and retirement accounts. Powers of appointment is where somebody in another will gives you the power to appoint when you pass who receives it. Annuities and retirement accounts, you can designate a beneficiary there. Generally, it's non-probate unless you name your estate as the beneficiary. And the encumbrances, as I was mentioning earlier, only put the encumbrances down of property that are listed here. You do not have to list the unsecured creditor's claim. So we started the probate process with the application. 30 days after appointment, we do the information to heirs and devisees. 90 days after, we do this inventory and appraisement. And then you'll get a bill and it's based just on the probate assets, and it goes to the county general fund. Here's an example of the creditor's notice, and it runs once a week for 3 consecutive weeks. And the first publication is that first date, April 21st, and it runs 8 months from there. If you got a creditor's claim, this is a typical copy. It's generally a pink form. Again, you can use any color form. You don't have to use the colors we have. All are acceptable. But a creditor will file a claim. What you can do is you can send a notice of disallowance as indicated down below, or you can show it's been paid. So if it's a claim, we're looking for that it's been satisfied, or it's been compromised, or that the notice of disallowance is sent. And individual that has the claim can, this is a notice of allowance of claim that you could indicating that you're allowing it. There's forms for everything, just keep that in mind. The creditor could petition for allowance of claim. And here's an order related to the claim. As we get to the end of the estate, for the real estate, you file what's called a deed of distribution. Again, it's filed at the Register of Deeds office. And this deed, it shows that the personal representative is giving up their rights to the property in the estate. And you want to do this at the end, make sure you don't have any creditors' claims. Deed of distribution then is fill out the, you'll need an attorney for this. It's considered in practicing law, so our clerks can't help you with this. And just a normal deed filed at the registrar's office. When you get ready to close the estate, there's a couple ways to close it. One, if you're the sole heir, sole devotee, so you're the surviving spouse, everything's going to you, you can file a verified statement to close, which is this right here, basically saying that I'm entitled to everything and there's no other family members. The normal way is doing the closing documents, which include an accounting. So we'll file an accounting, it's got detail, and then we'll also file a proposal for distribution. And then we can also file a receipt if we receive property. If we can get people to sign a receipt and release, that's even with waiver, that's better. And then we're going to, people can waive the filing of the closing documents. If they don't waive, then we send them a notice of right to demand a hearing. And then we file an application for settlement. And then we got something in the chat. I'm going quick. Question is to say if I have a remainder in law. I would say we have what's called the anti-lapse statute. Maybe I can try to explain that. Is that what you're asking? Or if the last person to take is the state of South Carolina, and I've never seen a case where that's happened. We do have the anti-lapse statute. So if you leave property to a lineal descendant, family member, and they predecease you, if they had issue that could take, they would, unless in the will you exclude them. So, but if you say, I leave all my property to Joe, and that's where you stop, and Joe passes, if Joe had children and he's a lineal descendant of the decedent, then his children would take the share that Joe would have taken. Does that answer? Yeah.
No. I have the neighbor, his mother lived in Maryland, I believe it was, but what they did to the deed, his father had passed, it was just his mother, and then he and his brother. And what they did on the deed was they were listed as what's called remainder men. And it allowed the mother to still retain ownership of the house and live in the house until her death. But upon her death, the house went to the two brothers, the sons, and it didn't have to go through probate.
Yeah, that sounds like a good little tool there. I guess what we have in South Carolina is the joint with right of survivorship, but then it wouldn't have to go through probate, but then that puts the child on there as an owner. The other thing we have is the life estate, where mom can gift away the remainder, but she keeps the life estate. I have not seen the remainder man, but I need to ask, but that sounds like a pretty good tool there, because that's what a lot of people want to do. But
Yeah,
then-
when I looked it up online, it's only in about 4 states. And I didn't, as of 2020, and that's all I could find.
Yeah, that's actually what most families are trying to do, because the parent doesn't really want to give up all the value, but they also don't want to go through probate. So that seems like it accomplishes both things there.
Right. And what was that first term that you used? Joint what?
Joint with right of survivorship. So that's kind of what we see prevalent in South Carolina. It used to be what we call tenants in common. And tenants in common mean that husband and wife each own 50% and can control 50%,
Okay.
if you follow me. And then
Yeah. Mhm.
joint with right of survivorship means whoever the surviving tenant is would take the property. The problem with that is the parents then putting the child on there. The child has issues or they own part of the property.
Right. Yeah. And we didn't want to take.
That's pretty good. That's a good little tool. I'll have to look at that. All right,
Yeah,
Jamie,
yeah.
make a note of that. We got to get law clerks looking at that, and we'll have a new bill for the state legislature. That sounds like a good one. Yeah. Thank you for that. Yeah. Other questions? Anyway, what all these forms are saying are basically you're going through a probate and you're laying out what you did as the personal representative. If anybody has a problem with what you did, they would file an objection. But first off, you're going to let the court know that you gave notice to the takers. Notice here at the end, we only have 2 of the kids listed. 2 of the other kids that who do not take, they're not listed at the end. But I wanted to give you let me go back to this form right here. This is a notice of right to demand a hearing. So basically what you do is you do everything administratively. You send them the accounting, the proposal for distribution. If anybody has an objection, then they have 30 days to come forward. Most of our states go through without any objection, but if somebody wants to ask a question at the end, we would have a hearing based on that. Oh, and I would note receipt with release and waiver. Many times family members will not sign that because they're forever discharging the PR of any responsibility. But if somebody's getting one specific item, they generally don't have a problem signing that. If you got family that would agree that, mom's probated the estate and we don't need to see everything, they can waive the statutory filing requirements. And we talked about notice right to demand a hearing, application for settlement, proof of delivery. You would then get an order closing the estate. And the other thing I would mention is once the order closing the estate, if you later then find additional assets, you can reopen the estate. It does not reopen the creditors period, but you can reopen the estate. And there's specific forms for that. Again, the probate practice is very much a forms practice, and we got a form for about everything you need to do. And y'all must have some other questions, comments. If you get behind in probating the estate, we send out a very nice letter saying, hey, we're looking for the inventory or looking for this document. Please try to respond to that. If we don't get a response from the first letter, then we send out a second letter and say, hey, we sent you the first one. Can you please respond? Court administration in Columbia is looking at our file. So we then send out a third, which is a notice of right of a hearing, maybe a rule of show cause hearing. And we generally don't want to get there. We're here to help you. If you need more time, just let us know. We generally need something in writing, either an email or just a short note that, hey, we're behind in probating this estate. Can you give us a little bit more time? Other questions, comments, things that we can help you with? What else are we seeing? I did mention a surviving spouse has a right to an elective share. So what that means is you don't have to leave property to anyone in South Carolina, but a surviving spouse does have a right to claim a 1/3 interest in the probate estate. And they have to file within 8 months once the probate is started. So make sure you file if you ever have an elective share issue. If you are an omitted spouse, that means somebody did a will years before they even knew they were going to get married. They then get married, not realizing that they had that earlier will, and they omitted their spouse they didn't know. That spouse will take the intestate share that they're entitled to. Could be the entire estate, or it could be the entire half the estate, and the children share the other half. A child, similarly, if they're not listed in the will, a pre-committed child, if you say everything to 2 kids, and then another child is born later, that 3rd child would take the same as the other 2. But the main thing we have concerns about are the power of attorney. It's a great tool. It allows you to avoid that conservatorship, but make sure you get somebody in there that you can trust. And then with the joint account with right of survivorship, make sure you put the local child on there as the agent under that durable power of attorney. Trying to think what else. Any questions, concerns? Jamie, is there anything I missed or I need to highlight?
No, sir.
I kind of went through that fast. I was about 1 hour and 15. A little bit over than what we thought, but it's all good. And we have other workshops, and this will be recorded. So if we can ever help you, remember choosing an attorney, talk to friends and family. You can use Martindale Hubble. Remember to take a ski vacation, and we're here to help you. Questions? I'll stop the screen share.
Thank you.
Oh, you're welcome. You're welcome. Good to see if you have
Thank
any
you.
questions.
It's been very helpful.
Okay,
And-
good.
Questions, we know what to do.
Okay, good enough. We're here to help.